Today, we're going to be discussing a bond. Not James Bond, but a probate bond, also known as an estate bond. What is it? Why and when do you need it? And how much does it cost? Today, I'm going to answer those questions and more in this video. Hello again, this is Certified Probate Real Estate Specialist Daryl Williams with Win-Win Realtors here in Southern California. On this program, we assist personal representatives and attorneys with real property that's in the probate process. If you are interested in this type of content, please like and subscribe. Let's get started. What is a probate bond? A probate bond or an estate bond is a type of surety bond. A surety bond guarantees the performance of a contract or obligation. The bond serves as a type of insurance policy for beneficiaries, heirs, and creditors. If a claim is paid out as a result of mismanagement by the personal representative, the personal representative will have to reimburse the bond company up to the amount of the damages expended. In most cases, the bond company will need to run a credit report on the applicant to determine if the applicant is bondable. Here are some common types of bonds: administrator bond, an executor bond, guardianship bond, conservatorship bond, a fiduciary bond, a trustee's bond. The type of bond you get depends on the role you are performing. Bonds are underwritten by an underwriter. I have seen several petitions denied because the petitioner was not able to secure a bond. Who needs a bond? Generally speaking, every person that's appointed personal representative must secure a bond prior to letters of testamentary or letters of administration being issued. If there are two petitioners, the court may require each petitioner to secure a bond, or the bond may need to be a joint and several bond. When is a bond required? If you are a non-resident of the state of California, or if you are requesting full authority under the Independent Administration of Estates Act. This type of authority allows the personal representative to act without court supervision. When does the court not require a bond? When the will states bond is not required, or the bond requirement is waived by all of the beneficiaries and the waivers are attached to the probate petition. How to get a bond? Contact the local surety bond company. You'll need to fill out an application, and there are certain court documents you will need to submit to the surety bond company. How much does a bond cost? The cost of the bond is based on the personal representative's creditworthiness. A bond normally costs about 5% of the amount of the bond. For example, if the amount of the bond is $200,000, then the cost of the bond will be $1,000. If the bond amount is more than $250,000, bond companies use a type of sliding scale to determine the cost of the bond. Alrighty then, there is the who, what, when, where, and why regarding a probate bond. If you are applying for a bond and you don't have an attorney, it can and probably will be more difficult for you to secure a bond. So those of you that are representing yourself in the process, make sure you are aware of that. Remember, the judge will not sign off on the issuance of letters until you have a bond in place. And remember, the letters of testamentary or the letters of administration is the document that gives you the authority to administer the estate. A bond ends when the case has been discharged by the court. If you've gotten value from this video, please like, share, and subscribe. And if you have any questions for me, my contact information is in the description. Thanks for watching Win-Win Realtors TV. I'm real estate broker Daryl Williams. I'll see you in the next video.